In today's Market Insights in navigating Sri Lanka's capital market, we have Buddhini Herath, an attorney at law who is also attached to Legal and Enforcement Unit of Securities and Exchange Commission of Sri Lanka. Hi Buddhini.
Hi Shivi.
The SEC Act has undergone a significant regulatory updates over the time, Buddhini, especially regarding to the market offences. So could you give us some highlights, the differences between the old and the new SEC Act regarding to addressing those offences?
Yes. So the old act was enacted in 1987. Of course, it was subjected to 3 amendments. However, the markets have evolved and market dynamics have changed. Our markets have developed and there are a lot of changes internationally and also locally. Therefore, after a number of years of deliberation, the old act was repealed and a new act was passed in 2021 September. So it's called Act number 19 of 2021. The old act had only 2 methods to deal with market offences. When it comes to dealing with those market offences, the only enforcement actions which were available under the old law were prosecution before the magistrate's court by way of summary trial, or compounding. Those were the only methods available. So basically the evidentiary burden was beyond reasonable doubt, which was a heavy one to discharge when it comes to the SEC as the prosecutor. Whereas in other countries there are methods of civil action and administrative action which are possible. So the new act has introduced those enforcement actions as well. However, when it comes to the new law, there's the Part 5 offences and other offences have been divided. Part 5 offences are the 2 main offences: market manipulation and insider dealing.
Are these the ones called as under the category of prohibited conduct?
Prohibited conduct are the market manipulation, whereas insider dealing is dealt separately in a separate chapter. There are 5 types of prohibited conduct which is identified in the new SEC Act and comes under market manipulation. So under the old law, when there were only 2 enforcement actions which were possible, under the new law, the more serious offences are dealt in one manner and the less serious offences are dealt with in another manner. When it comes to market offences, which we consider are more serious, that is insider dealing and market manipulation, they are now indictable before the High Court if the SEC decides to proceed with criminal prosecution. It is no longer before the magistrate's court. Whereas under the old law, all actions were before the magistrate's court.
Everything has to go to the magistrate court.
Everything had to go to the magistrate's court. The less serious offences, which are other than Part 5 offences, can now be dealt with before the magistrate's court, or we have something new called administrative sanctions. Part 5 offences other than Part 5 offences can be dealt with by way of administrative sanctions. So for those are the violations of the SEC Act, rules, regulations, conditions of licensing conditions, as well as rules of a market institution. So those are the 2, and also those lesser offences are compoundable. For an amount which is half of the maximum fine imposable. So which is, you can go up to 50 million. Because the maximum fine imposable for lesser offences is 100 million. So half is 50. You will see that means the amount has been enhanced. Whereas under the old law, the maximum fine imposable was 10 million. So and compoundable amount was 1/3, which is
1/3 of that 10 million.
That 10 million. So the maximum amount that was compoundable for offences was considered as 3.3 million. Whereas under the new law, for lesser offences, compounding can go up to 50 million.
Understood.
When it comes to more serious offences, that is market manipulation and insider dealing in Part 5, the action can be instituted in the High Court by way of indictment and by the Honourable Attorney General. In addition to that, the SEC can decide whether to move by way of civil action before the High Court as well, considering the serious nature of the offence, the loss to the investor, the market impact, and so on. However, in the High Court, the court can impose a penalty as well as direct the wrongdoer to pay 3 times the profit gain or the loss. 3 times of the profit gain and, or the loss avoided plus a penalty.
Right. Okay.
In addition to that, there's another method of resolution that has been introduced, that is by way of settlement agreements.
Okay.
So that may sound like a shortcut to a wrongdoer, but the SEC, all the other methods, that's criminal, regardless of the availability of criminal prosecution and civil action, the SEC can still decide to settle an offence by way of a settlement agreement.
Okay.
However, he is required to pay 3 times of the profit gained or the loss avoided.
On the particular transaction?
On the particular transaction or the series of transactions.
Right.
So it can constitute one transaction
or
a
multiple
series
transactions.
Of multiple transactions depending on the facts of the case. So that is the difference between the old act and the new act as to how offences are dealt with.
Bodhini, we spoke about the prohibited conduct under market manipulation, and you said about some 5 key offences, correct?
Yeah.
Could you walk us through the essential element which we have to establish to prove those offences?
Yes. When it comes to market manipulation, there's a separate chapter dedicated for market manipulation, and 5 key offences have been identified.
Okay.
They are basically how offences can be committed. And whereas under the old law, we only had a SEC rule in Rule 12 and also Rule 13, where it's very broadly defined market manipulation. Whereas under the new law, the instances or examples of how market manipulation could occur, and they are being identified as prohibited conduct and are listed there.
Okay.
I'm not saying that the examples are limited only to those. Depending on the facts of the case, market manipulation can differ, but compared to the old law, the new law have identified instances when market manipulation could occur. Under the old law, the market manipulation offence was limited to Rule 12 and Rule 13. It was not there in the SEC Act. It was very broad, general. Of course, any type of acts which would fall into the category of market manipulation could be fit into that rule based on the facts of the case. However, the new law has brought in market manipulation into the SEC Act and has categorized and identified the instances in which market manipulation could occur. I'm not saying it's an exhaustive list, but these are examples of how market manipulation could occur.
Understood.
Of course, it will depend on the facts of the case. The 5 categories have been identified in a separate chapter under prohibited conduct, and they have been listed as false trading and market rigging transactions. That's in section 128.
Right.
And in section 129, inducing another to trade based on transactions is identified as stock market manipulations.
Right.
And making false or misleading statements have been identified under section 130. The mental element have been categorized to 2, that is, making false or misleading statements or disseminating them have been taken as doing without taking reasonable care or with knowledge that they are misleading or false. So that's the 3rd category. The 4th category is fraudulently inducing persons to deal in securities. I told you the third category is making false or misleading statements, either recklessly or knowing it's false. This is by way of that you induce another to trade. And
intentionally you induce someone.
Yes, intentionally. This has 4 categories based on the mental element, and knowingly doing it is one, and dishonestly concealing material facts is another, and recklessly making or publishing dishonestly or otherwise making any statement or forecast which is misleading, false or deceptive is another. Yes, and also storing such false or misleading information has also been made an offense. So there are 4 categories. The 5th is which are made to defraud another. Therefore you can see all these have been identified based on the type of action or the mental element of that is involved when it comes to market manipulation, and they have been listed down as instances as to how market manipulation could occur. As I told you, I want to repeat, this is not an exhaustive list. This actually clarifies how market manipulation could occur and prohibits them. So these provisions bring clarity to the law as to how market manipulation could occur.
In terms of, for the benefit of the viewers, could you briefly explain under what circumstances a person is considered having committed an insider trading, Budhini?
Yes, insider trading was limited to individuals under the old law. Under the new law, it is not limited to individuals, but also can apply to a corporate body. So it is
as a corporate body itself, it
can because they also can have CDS accounts and they also can trade. Under the old law, if a corporate body trades and if it is considered insider dealing, we could only prosecute an individual who has procured or communicated information to that corporate body. Whereas under the new law, any person can be considered as an insider. However, under the old law, there was a requirement that an insider has to be a connected person. Whereas under the new law, there's no such requirement as long as if a person trades while in possession of information which is identified and defined in the law.
You don't have to get connected, but as long as the possession of the information itself can
possession of when a person is in possession of information which is not generally available but can have a material effect on the price or the volume of a share, and he knows that it is not generally available, he is not supposed to trade. So that is the restriction as to insider trading. What is information is defined in the law, and I must emphasize a lot of people have this misconception. As long as a board resolution as to a particular information, that is where the information becomes certain, or that the restriction on the board or any person who's an insider arises. However, that is not the case. What I want to emphasize is that as long as there's a certain amount of certainty to the information, that is sufficient, and the prohibition for an insider not to trade arises there. For example, I want to just read you what the information is defined as. Information relating to listed public companies that are not sufficiently definite to warrant being made known to the public. Matters relating to intended decisions of a person. So you can see it may not necessarily be information originating from the company, but it can be relating to intended decisions of another. Matters relating to negotiations or proposals with respect to commercial dealings or dealings in securities. Information relating to the financial performance of a company. information that a person proposes to enter into or has entered into one or more transactions or agreements in relation to securities, or has prepared or proposes to issue a statement relating to such securities, and matters related to the listed public company that have been decided to be executed in the future. So you can see, as long as there's a certain amount of certainty as to the information,
some certainty
into information, there's no necessity to have been a board resolution before for the information to have been certain. So what happens is, we have come across situations where insiders have traded before the board resolution when the negotiations are going on about 2-3 weeks beforehand, but there's a certain amount of certainty that the transaction would occur, or that the company would pass a resolution, or that the transaction with regard to the company would be executed. So the lot of people or the insiders who we allege to have committed insider dealing raised the issue. The board resolution came way after. However, as what we say is that you have abused that information you had with regard to the negotiations or the
with the intent they have used it anyway.
That is right, information of the company. So with the intent, what is prohibited, or what the offence tried to stop or deter is the unfairness that occurs when somebody deals with shares of a particular company.
It's all about fairness, right?
Possession of inside information. It's all about fairness.
We see with the rise of retail investors turning into social media for investment advice. Some people give advice like, at a rate, and the general public also listen to them because they are influencers, they become industry leaders at times. Concerns about the credibility of the information actually have grown. Given these emerging channels, does this new SEC Act include this provision to address this false or misleading statement made online or through any other platforms? What's your take on that?
So it's not that the old law or Rule 12 could not deal with manipulations that occur by way of information that is disseminated on social media or any other platform. It could be newspapers, it could be YouTube, it could be forecasts. What we see is that happening increasingly, or there's with the digitalization of the CDS accounts and online access to CDS accounts, and also the use of online and social media that has increased, and the reliance on those by those investors who are not very familiar with trading, and to have an easy way as to educate themselves has increased this
pattern of giving advices,
of turning to those persons as well.
Correct.
So market manipulation can be trade-based or information-based. Under the new law, the trade-based manipulation is identified in section 128 and 29, whereas information-based market manipulation is identified in 130 and 31. So the instances you talk about as to addressing dissemination of false and misleading statements are there in section 130 and 31.
Right.
So if you disseminate false or misleading information recklessly or knowingly that it's misleading or false, you fall under the category of section 130. Whereas under 31, inducing another to trade based on your false or misleading information falls under section 131. So what 131 says is that a person shall not induce or attempt to induce another to trade in securities traded on an exchange by making or publishing any statement or by making any forecast that he knows to be misleading, false or deceptive. So the knowledge is there. Whereas somebody might
Intentionally do that. You mean to say.
Yes, intentionally or dishonestly do it by
Correct.
concealing material facts
Right.
when you make a statement.
Right.
That comes under B. Whereas another person might copy what is available on another
Yeah.
website or in another user and then publish it in
their own
his platforms, either place it on Viber groups or WhatsApp groups or whatever the social media groups.
Yeah.
So that is considered reckless. So that is identified under the third category by reckless making or publishing dishonestly or otherwise of any statement or forecast that is misleading, false or deceptive. Also, storing in electronic devices and saving them information that you know is false or misleading has also been identified as an offense.
Oh, really?
So that is how what you are talking about has been addressed in the new law.
So just a question, like when you say storing, like if I get a WhatsApp forward and I store, I mean probably I know or I don't know, either way I store it, then that is also coming under that particular provision.
If I'm giving you legal advice, let me read it to you.
Okay.
So, by recording or storing in or by means of any mechanical, electronic or other device, so it can be a USB, a CD,
anything,
whatever, information, your answer is here, information that he knows to be false or misleading in a material particular. So, what you wanted to know is whether you will be caught, provided you knew it's false or misleading. So you have to show that you did not know it was false or misleading.
Before I press that save button, I should be knowing that.
I suppose.
Wow. Okay, so that was interesting. Thank you, Budhini. Thank you so much for giving us the information that required on market insights on capital market today with us. Stay tuned for more.